I call this meeting of the Town of Clayton Board of Adjustment meeting to order. We have all members present, 5 voting members and 2 alternate members. Do we have any adjustments to the agenda? Hearing none. Third, item number 3, approval of the minutes from the July 21st, 2021 meeting. Anyone have any comments, corrections? Move for approval.
Move for approval.
Do we have a motion for approval? Do we have a second?
Second.
Do we have a motion to approve and a second?
You clarify who made the motion for us.
Yes, Mr. Perricone made the motion, second by Mr. Casey. All those in favor say aye. Opposed? Motion carries. All right. Seeing we have no public hearings, we'll move to item number 5, which is old business, and that is the review of the findings and conclusions from our previous case heard on the July 21st meeting, the 2021-56 variance for O'Neill Overlook variance. And Town Attorney Raspberry, do you like to make a presentation for us on these?
Mr. Chairman, just not to belabor details, I'm not the town attorney. I'm the attorney for the Board of Adjustment for the moment.
Right.
But we had sent a copy of the suggested or proposed findings of fact and conclusions of law representing your final decision in the variance case. This is suggested by your counsel, and if anyone takes issue or feel that it's too long or otherwise wants to edit it in some fashion, that's perfectly fine, but I believe you all have been provided copies previously.
Okay. I assume everyone has had a chance to review those findings. I myself have read through those, and I do not see any changes. They seem to be very accurate from the meeting on the 21st. Anyone else have any comments or corrections that need to be made?
My comment is, do we have to vote on these?
Yes, sir, I think that's
My understanding is that we have
Yes.
to vote to approve the
Yes.
findings.
We have to vote on, did we vote on this last meeting?
My understanding, we voted on the variance, and it was approved.
The grant, the variance was approved, and this, of course, is the final decision document. The order, the final decision has to include findings and conclusions, and it is for signature of the chair, which is a statutory requirement. So, I mean, I understand the point about there being action taken to allow the variance, to grant the variance, but this is the final decision document, including findings and conclusions in the case that would need to be voted on separately, because it's conceivable that some member might want to add or delete something or suggest edits to them. So this is the formal decision. So a vote would need to be taken on whether this is going to be your final decision or not in this case.
So my question is, does it make our first vote null and void?
Yes, sir, because the decision was to grant, and this is entirely consistent with that. The decision is to grant. It's the final paragraph in the document, actually.
Is it fair to say this is supporting documentation for that decision, and we're simply
Yes, sir.
providing the documentation now and approving that documentation to confirm what we've already done?
Yes, sir.
Is there a way of, first meeting that we did this, and we voted on it, and I understand the city of Raleigh said allows the developer to go ahead. Is there a way of making our first vote the decision voting and adding this document into it later next week and the week after, but not making it something we actually have to vote on? Because we've already voted on everything in here. I'm concerned about holding up the developer for another 30 days, given the opponent 60 days to do an appeal. I mean, the process from day one of a developer is long and hard as it goes through government anyway. I'm just not in favor of adding 30 more days to his walk.
Chairman, I understand the procedure for reaching a decision at the night of the hearing, and then what form the final decision document takes, and how that is prepared and approved is an open question. And I understand there's been conversation amongst town staff and town council about this, and we've talked about this as well. The method where the board acts in summary fashion to either approve or disapprove a request generally is taken at the meeting, and you all took that action, made that short and sweet decision on the two variance cases you've heard the night that the hearing was concluded. Our office suggested that we would be happy to prepare findings and conclusions to serve as the final decision document to be presented at the next regular meeting. Raleigh's practice, which again, not to hold that out necessarily as a model, but my experience with Board of Adjustment in Raleigh, and I think it's true for other mid-size and larger municipalities. I know it's true of Morrisville. I know it's true of Ashboro. And of course, we could do a poll just to look at options, but is the practice in those municipalities is for there to be a vote up or down at the night of the hearing. And that is the will of the board. And it's entered into the minutes. At least in Raleigh's case, at that point, the city administration notifies the applicant that, and again, it could be, the decision could be to approve, disapprove, or to approve with conditions. But whatever that decision is, the town staff or the city staff notifies the applicant of the action taken. If, for example, it's to approve a variance, a notice of decision is delivered to staff, and the developer at that point effectively has the green light to continue to make submissions, apply for further permitting, and to proceed with the project, understanding that the final decision, which has to have findings and conclusions and be signed by the chairperson by law, the final decision will not be signed and will not be truly final until 30 days later. And that does create a circumstance where you have 30 days before the summary decision is taken, then you have the final adoption of findings and conclusions 30 days later. And then that is the final action which initiates the time period for filing an appeal. And during that period following the final decision, signing of the final adoption of findings and the signing of that order by the chair, then the applicant has 30 days plus typically 3 days added to allow for the service of a copy of the decision upon him or it to initiate a petition in Superior Court, which is the appeal from the decision. So that's the timeline under this 30 plus 30 scenario. And it would be advanced if you decided to reach your final decision, adopt findings and conclusions, and have a document signed by the chair at the meeting or at the hearing when the decision is taken. And it is your choice. I think most medium-sized communities take the position that a final decision document should have some findings with particularity concerning what you drew from the evidence the findings that you reached from the evidence and how it led to your conclusion. But some smaller towns, from my experience, adopt only the 4 statutory findings, which legally speaking are probably conclusions of law, since these are the legal criteria, and you're simply saying these 4 legal criteria have been met. You haven't recited any of the facts that you've found that support that conclusion. There's no law in the state on whether that, I'll call it abbreviated process, is valid or not, but plenty of smaller towns do that.
That's how we've always done it.
And that's, I'm sorry.
So that's the way we've always done it, whether it's right or wrong.
I understood that's the case, and Mr. Hales may want to chime in on this because he has plenty of experience in this area as well.
I've worked in Durham and Greensboro, and they did it differently from each other. I think during the last month or two, some of the discussion on the staff side has revolved around, I guess, 2 issues. One is if he could do a draft of the findings and conclusions prior to the public hearing, relying heavily on the staff report and the various relevant parts of the ordinance, adopted plans, and so on. To have it there might possibly make members of the board also feel more comfortable that they've got something a little more specific to work from in making a motion. I've seen that happen before, and in that situation, if it's drafted up in a legally acceptable fashion prior to the hearing, I think at least one jurisdiction I worked with used to rely on that to produce something that's legal in legal format, proper legal format, but to do it in advance so it can be part of the motion and it can be even referenced in the motion. That's one approach. Other thing staff's been talking about is since we have to produce minutes of your meeting before your next meeting and send it out to you, would a different approach be to attach the findings to the minutes, and therefore your action to adopt the minutes of the next meeting would include that, and it would have it out there, wouldn't have the findings and conclusions voted on separately, but as part of the minutes. I don't know either of those, but I think those are some things we were talking around, because we've certainly heard some comments like Mr. Satterfield mentioned about this seemingly for a new board and a new, partially new process here, having some impacts on some folks getting their plans approved through the process there. So I'll just toss those things, 2 things out there.
Well, Dick, since you're at the podium, I think, and I don't want to speak for you, Bob, but I think I understand the concern. Our biggest concern is it's not holding up someone moving through the process. Is it holding up the process, or would it hold up the process? Say, would staff say, okay, your findings have not been approved, you can't move forward?
All right.
How would that be looked upon by staff?
Well, I think from the legal standpoint, what Attorney Raspberry said is true. I think we're finding, we've had 2 variances approved, and we've had some interaction with the developers involved, and I think they're both trying to find ways to move forward. You know, everyone's a little different in terms of, you know, how much construction drawings or other permitting might be required prior to moving forward. Variance a lot of times is the last thing. If they have a subdivision or a site plan, we encourage them to do that in advance of coming here, since an appointed board is a higher authority than staff approval, so we try and make them come to the board last. But there's still lots of stuff going on in terms of bidding out construction and filing building permits and other things. I think in each situation a little different, but if someone wants to be aggressive and to move right on after the public hearing and a favorable decision, some people are doing that. Now, I will note that we had Mr. 2 down here the night of adoption of the findings a month after the Crawford Cook Shack came up, who was questioning the findings and conclusions. It was not a public hearing. The board allowed him to speak and make a few points. I think you also noted he was getting a little long-winded on some of his points as well. So I think that's a reminder to some that the format we're using now does have it hanging, appear to hanging out there in public as not fully approved until the findings come through. I know people that are hearing about this for the first time and are not used to the findings and conclusions separately approved are concerned about it. I think in reality, on the 2 we've had, each of the applicants, as we've heard, have been trying to move forward and not frozen in time. I think the potential for an appeal on the Crawford Cook Shop is a more serious issue, because if in fact an appeal's made and it goes up to the court and have to, a minimum of, I would say, a couple months before they hear back on that, there's more risk there on behalf of the developer, felt to be that at least.
Understood.
May I offer a couple just opinions from the fact that there's obviously a tension between making business decisions here and what the legal consequences of our actions are. So those are the 2 things that we're trying to balance, obviously. From the business perspective, the expediency of understanding that a decision was made and allowing a developer to move forward in this particular economic climate, I think is very acute from the perspective that we are seeing, I'm a general contractor, we're seeing price escalations that we haven't seen in probably 20 or 30 years on a monthly basis. So some relative certainty that a decision has been made is extraordinarily important for a developer's perspective or a contractor's perspective right now. If there's a balancing of risk, as you've so well put, between the cost involved in drawing and procuring estimates for construction, that right now I believe would be offset from a protracted time period. So time right now is probably more valuable than the actual cost of developing drawings and going through the permitting process. So I would say that if we're, just my advice would be, we should have some 2-part process. If it's a very simple notice of decision, it's approved, not approved, those are 2 options, right? That would allow some business certainty to a developer to proceed and move forward. If it's approved with conditions, then obviously the facts of the decision become much more important, and I think that's a different measure altogether. But the other side of this, just to kind of parlay in, or to segue into that, is that the finding of facts, and again, the example of these 2 decisions that are made at the Crawford Cook Shop, we have a resident that's unhappy with that decision, clearly, and the findings of fact become much more important in that scenario because it is more likely to have a legal challenge. So therefore, we have to have these documents approved in a public manner to preserve the record and the decision of why we made that decision, okay? So I think that there's probably a balancing here somewhere between expediency and preservation of the record for legal purposes, and just common sense speaking, I think that having a notice of decision that has some certainty to move forward for a developer, and then later following up with this document makes a heck of a lot of sense based on what we've seen already in just two cases that are pretty straightforward. One of them likely to be challenged. The other one made very practical sense from every aspect as you look at it and should go forward, right? So just take that into consideration.
I agree with everything there. My sticking point is whoever opposes a project has 60 days to appeal it. That's what my sticking point is. Instead of the written 30 days, he has 60 days to appeal it. He can appeal it after our first meeting, another 30 days, we vote on it, we approve it again, he has another 30 days after that.
I think that I understand what you're saying, that getting this right should not be done under haste, okay? Especially if there is risk of an appeal, then this has to be right.
Well, everything that's in here
What I'm saying
is
is finding the facts have to be right.
on record already, is that not correct? Everything that you've written up is on record, not unless you just sort of interpreted what we had to say.
But this will be the first document that a court will look at under an appeal. And this again, I'll let the attorney speak to what happens here.
Well,
'Cause I'm not, that's.
we got two attorneys down there. What I'm asking is this document any different than the records of that first meeting?
Let me respond to that. The record is everything that was heard by you and received by you. The findings that you make reflect what you chose to believe and what you chose was important and what you found to support the decision that you made. So those are two very, very different things. The record is everything,
Right.
good, bad, and indifferent.
Right.
This is just a reduction to a document that should support your decision.
Your legal opinion, is there any way of speeding up this process to where someone opposing a project has not 60 days, 30, 45 days to do an appeal?
Does the appeal process have to be 30 days?
I thought the appeal didn't begin until we approved this document. I thought that was the opening date for the appeal, not our decision.
Correct, sir. The appeals period begins to run when the chair signs the final decision document, which is essentially synonymous to the written findings and conclusions and the decision.
Okay, Mr. Perricone evidently didn't hear you right or something, or I didn't hear you right one. He's thinking the appeal process starts after the first vote. It doesn't. It starts after the second vote, which is 30, 60 days later.
So they have.
After the sign.
So they have 60 days after this document is signed in order to.
No. They have 30 days after this document. They have 60 days from our initial vote. That approves it.
I didn't think they could file the appeal during that first 30 days. That's what I'm saying.
No, but it's effectively 60 because you got to run the two together.
30 days after signature, after findings are filed,
Sequentially.
but 60 total.
60 days in terms of practically preparing the appeal.
Yeah.
Gotcha.
Are we required to give 30 days for an appeal? Is that legal? 30 days, is that legal?
Right. 30 days to file a petition for certiorari. Now, the court may take its time as to when it signs that document, and then it takes a period of time to assemble the record and have the record approved by the court as the certified record. So there's no question the appeal process, once an applicant or an opponent decides to initiate the appeal process, it's drawn out. It takes a while. And also be aware that there can be an appeal from the decision, and then there can be an appeal from the Superior Court ruling on the appeal. So there's, just to point out that there are cases where the uncertainty may last for a good period of time if the parties just choose to fight over it long enough.
With seconds here, and you're talking minutes and hours and days. So my 30 days is probably trivial compared to what it could be.
Just again, and the order can be moved for a stay in the court. So there could be an approval of a permit, and an opponent could convince the judge to stay that order pending the appeal. So, there are various ways that an appeal can go that drags out the process. But I fully understand, Mr. Satterfield, the issue of should it be 30 days before the business is consummated, the Board of Adjustment's business is consummated on a case, or 60 days. And I made the point, Mr. Satterfield, our firm is certainly not lobbying to have, to be assigned the responsibility for drafting lengthy findings and conclusions after all the cases you decide. There are plenty of options. We have no horse in the race.
Can I just ask you a couple of questions from a practice perspective? This document, the findings of fact, how does the court view that document? What weight does it give it?
The standard, let me answer you this way. The standard on review is whether the record contains substantial evidence to support the decision, not whether the fully adopted findings and conclusions are perfectly drawn or perfectly tied together, the evidence with the findings of fact, with the 4 statutory conclusions, with the decision. It's not that fine-tuned an examination of what you did. So if the evidence is there, we can make a case to support your decision. I just have some concerns with a municipality that only approves the 4 statutory findings/conclusions. An appealing party could say, you're required by law to have findings of fact. There are no findings of fact that you have signed on to. There is no order that includes really findings of fact that support the decision. And the legacy court decision that says, if you tell someone they can't do something with their property, stands for the proposition that the deciding body has to show, by way of written findings, what was their thought process and what was the basis for their decision. Because a frustrated party, a disappointed party, really doesn't know what the decision stood for.
So
That's the principle involved, and that's where I'm coming from to suggest that it makes some sense legally to have a final document.
if I may, so under a review in Superior Court, where the court first looked at the findings of fact and considered them and give them greater weight than the general evidence that's presented in the case?
As the lawyer for any quasi-judicial board, I think it always is easier to defend a decision document that shows a high professional level of decision-making process. And to me, if you have findings and conclusions that do that show that it was a thoughtful decision, that connects the dots, evidence, findings, conclusion, that leaves a good impression on the judge, and that always makes it easier for the attorneys trying to defend the appeal, or to defend the decision.
So in a court case, if you didn't have the findings of fact, I would imagine perhaps that would draw out the length of the case and open the town to a lot more really be more subject to question, is basically what you're saying. And from an expedient point of view, and if I'm looking at this as I'm trying to develop something, I think that that document overlays a great more level of certainty over the decision that the board has made, even in the face of potential appeal. But that's just the way I look at it.
Makes the decision look better, and it makes it easier to defend.
Yeah.
I'm not sure I can add much to that.
So to address, Bob, your concern, take it out of the legal realm for a minute, and look at it from a risk assessment standpoint. So
thinking of this as, if we have a decision for, so what are the risks to the developer, what are the risks to the opponent? If we have a decision against, what's the risk to the developer, what's the risk to the opponent? Well, there won't be any opponents. If it's turned down, usually they're happy at that point, so that comes off the table. I think if you're a developer, you're probably pretty savvy. We've had 2 cases come through that are probably good examples of a range of things we're going to see. And with respect to risk, there's obviously more risk on the first decision that was made because it was controversial and there was opponents. The second one, there really wasn't. So the risk there is very, very low. And there was no dissent in terms of the board itself's decision, that they were all both unanimous decisions. So I'm thinking from a practical standpoint as a developer, like everything else I do, I'm going to assess the risk of moving forward against, getting stopped somewhere down the line, and that's going to be how I make the decision. I don't think the 30 days alone is going to be the determining factor. So I tend to agree having this document, if we have to defend it, is better than not having it, and having it prepared well works in our favor. The one thing I'll go on record saying is I'm not anywhere in favor of having something pre-prepared prior to the meeting. My concern there would be a perception that the decision was made by staff and we're just rubber stamping things, and I think that's a huge disadvantage going forward on all fronts.
I'm with you.
And maybe just to speak on all those, a little bit more on experience that I have dealt with professionally in a number of communities. I think what Raz has presented to us is very much the standard in the communities that we work with. Just one that we're doing now in a neighboring community. Our decision was made, at the table. We were then allowed to move forward with staff permitting, such as that. Obviously, knowing that the findings had to be, as we more consider, memorialized in the findings. That will happen, and I'll go further on that. A little side note: I really do like the idea that our attorney is preparing those findings. Some communities, Raz, require the applicant's attorney to prepare those findings, so I don't really like that, but some communities don't give you the choice. But those findings are, subsequently, prepared and then presented at the next board meeting, and they are memorialized. And, to Jim's point, and I think Tom's too, there is a substantial difference. If you look at Raz's findings, they are very precise and to the point on the findings of what actually the testimony presented said to us, and it memorializes it versus the minutes. I mean, you see a clear difference in the findings versus the minutes. So anywhere else I have ever worked professionally, there has had to be findings, and they had to be approved and signed, but it didn't hold us up at process. Didn't hold us up on submitting CDs the next day if we wanted to. Didn't hold, Now, that's what I would not want, because like you said, Bob, the decision was made. So as if I'm a developer, I feel like I need to be able to proceed in that 30 days until the next board meeting. But really, those findings, in my opinion, are really memorializing what happened at that meeting. Very specifically, as you can tell, they're very, very specific. And I thought these were really good. In fact, I may use them as an example that they're very, very good. Very good.
And Kelly prepared these, by the way. This is a group effort.
Very good.
Doing these for you all.
But that's just what I'm seeing in other communities, and obviously we're Clayton. We want to do what's right for Clayton, but I don't see anything that we're doing that is out of the realm of hurting a developer or a petitioner, as long as they're being able to move forward with staff and their permitting development process. So.
Just offer one comment, and this is a follow-up to what Mr. Hale said. Raleigh, for example, has its attorney prepare findings and conclusions for all the cases that are heard at a given session. They are brought back not to be individually considered and voted upon, but they are part of the minutes of the previous meeting. So it's not necessary to take a look at the proposed findings and conclusions in each case. They can be bundled and just adopted as a package as part of the adoption of the minutes at the next meeting. The reason that this was these proposed findings were brought to your attention individually last month and now this month was because sort of the clerical processes haven't been worked out yet. And since this is a new thing, we thought it didn't make sense to just bury it in the minutes approval action somewhere. But in reality, that's the way it sort of gets done once you're up and running with this process. It doesn't change the timeline, obviously, but it doesn't invite the kind of conversation we had last month where a frustrated applicant will see the proposed findings and kind of want to pick at those and perhaps re-argue some points of the case, because that's not called for. Really, it's a formality, and typically you wouldn't expect it to be anything but routine, honestly.
Right, understood. Any other comments or questions?
Mr. Chair, if it's permitted, would it be of value, and this is a question to you and fellow board members, would it be of value to have the date set forth, at least for the board, so we know what, for each decision, what the appeal timeframes would be? And then it would be interesting to keep us apprised of any appeals that are filed. Can we, so we know what's
Sure.
going on?
It's a great idea. Do you understand the question there?
So,
I think so. I mean, the timeframe, I don't think it's going to change.
right, but getting hard dates. So as we, so for example, let's take the first decision, the Cookhouse. What's the final date for, final deadline for appeal, that we know that, and then, or when we come to the next meeting, have any appeals been filed? When we come to the next meeting, was any appeal filed? Just so we're cognizant of that information.
More information to the board item?
I think to address some of the discussion, putting the word out there that you are not blocked from moving forward on your project prior to adoption of the findings and conclusion, from what I've been hearing, will resolve some of the angst that has been coming up the last month or two here. I'm not sure it'll change the 60-day concern, Mr. Satterfield, but if we try and make it clear, subject to they have to agree to absorb some risk there, but then there's a lot of risk out there for different factors that are out of your control. But we will, I think, based on the discussion I'm hearing, we'll make an effort to try and spell that out in addition to the timeframes involved. Most of the people are pretty tuned in on the timeframes already, so I don't think there's a lot of unclarity there.
Well, I'm not worried about their clarity. I was worried about our clarity.
Okay.
Basically, if I'm understanding correctly, to have staff maybe keep up with these times as far as the appeal period began X date, it's over this date, there has been no appeals filed, just to keep us in the loop maybe.
Okay.
Or there has been an appeal filed, or.
I can tell you the 30-day appeal period ends this Friday on Crawford Cookhouse. Just
Okay.
get you up to date on that.
Very good. Is that what you're talking about? Yep.
Yes, sir.
Very good. Oh, that's great.
Thanks.
That's great.
What he said.
What was it?
What he said.
Absolutely what he said. Right. I think that.
Mr. Chairman, I'll just add that any appealing party has the responsibility for serving the petition for certiorari on the chairman of the board that made the decision. So all of those obligations are on the or on the appealing party. And if they file an appeal, it will not go unnoticed. You will most definitely be served with paperwork of all of that. And I would think that the board members
You gotta
probably
say that,
would want to be notified
Thanks, Raz.
if and when that happens.
And Raz, just for clarity, since we're on these, not to beat it to death, but these findings, they are recorded? These findings, the findings, are they recorded, are they required to be recorded?
Dick and I have had a conversation about that. Raleigh doesn't record them, Morrisville doesn't record them, Cary doesn't, as far as, I've never heard of a town recording Board of Adjustment variance decisions, but that had been the practice in Clayton, I understand.
Yeah.
You know, that, who makes that decision, I'm not sure. I think that probably is just a city practice that needs to be decided upon, but it is, from my experience, unusual. It's not required by law, that's for sure.
Yes. I've run into special use permit findings being recorded. You know, I'm not advocating for it by no means. I
understand.
Well, given the capabilities of this room, all of our public meetings each month, the town council meetings, the planning board, and the Board of Adjustment are not only recorded, but they are streamed live on the internet. So you can.
Yeah, I think, Dick, what I was referring to is the actual written findings being recorded at the Register of Deeds office.
Okay, I'm sorry.
That is done in
Another recording.
some cases. I'm not advocating for it. It was more of a question, so. But I'm like you, I understand it's been done here in Clayton, so.
The decision runs with the land, so successors in title do have the benefit of taking advantage
Yeah.
of a variance or special use permit that's been approved, or administrative interpretation that's been given.
Right.
But recordations, I think is somewhat unusual. It's certainly not required.
Okay, good. That's great. Okay, with that, if we are ready to vote, I'll entertain a motion to vote, or entertain a motion on the findings of fact.
So moved.
Have a motion by Mr. Pericon. Do I have a second?
Second.
Second by Mr. Casey. All those in favor say aye.
Aye.
Opposed? Motion carries. All right. Moving now down to item 5B, rules of procedure updates. As you remember, our last meeting, we reviewed the sample rules of procedure from Raz, and there were a number of comments, good discussion, and Raz has now presented us with a formal draft for our consideration this evening, and I hope everybody has a copy. Raz, would you like to review the changes or anything you'd like to say?
Be glad to, Mr. Chairman. I apologize for just getting these to you this evening, but the changes were extensive. There are 3 substantive and a couple of very minor editorial changes. The first suggested change, page 1, it's 3A. The red print text was added to address this issue of alternate members. What are their functions and responsibilities, and when do they participate fully in place of a regular member? And I think that's pretty straightforward. On page 3, I had the draft that you all were considering did not have the specifics spelled out regarding your meetings. And on page 3 in red up at the top, I'm not sure what your practice is concerning the month of the year. It may be July, but I wasn't sure, so I just put that question mark there.
Planning board has always used the beginning of the year, January, for those.
January 1?
Yep.
Okay, January. All right. Just however y'all want that to be read.
You might want to cross-reference the ordinance on that. sure there's not.
Or I should say the first meeting in January. Typically.
Can be done. Set out the regular BOA meeting date, third Wednesday of the month. And skipping to page 5, Roman numeral 5, the added language addresses the question of what is a completed application, and then provides for the 60-day time clock for scheduling a hearing after the board clerk finds that or accepts the completed application. Typo there in the middle of paragraph 7 was also corrected. And that's shows all the changes.
Yes.
One small point, back over on page 3, I believe the official title of this building is Town Hall. I know in some towns it's municipal building, but
Got it.
would that be appropriate for us?
It is.
I do have a question on section 3A. Regarding the 2 alternates, it doesn't list that one needs to be an ETJ and an in-town resident. Do we need to list that?
I'm sorry. I didn't.
Section 3.
Yes, sir.
Under members, under appointment, it says 2 alternate members, but it doesn't say that those alternate members need to be in the ETJ and city limits. Do we need to specify that?
That is a consequence of the way your code is written. Your code just simply provides that of the 7 members comprising the board, there will be 5 regular and 2 alternate members, and that of the 7, 4 will be in the corporate limits and 3 outside the corporate limits. Excuse me, and 3 residing in the ETJ. But it does not differentiate between the residency requirement for alternate members and the residency requirement for the regular members. So long as of the 7, you have that 4-3 balance. I mean, it is a little bit clunky, I realize that, but so you may have all the alternates be ETJ members, for example. That could be a result.
I don't know. I mean, is that something we can change if we feel it's necessary, or?
Well, again, I wrestle with it, and that this is consistent with the UDC and the town code. Mm-hmm. And there really aren't any directives there as far as how you parlay out between the regular and alternate members, the ETJ quota and the corporate limits quota. And I think, honestly, I don't think you have the authority to set rules on that. I think that's just governed by the town code.
Yeah.
I would also say some of those recusals and seating alternates can happen quickly. Like someone recuses himself from a case and no one knows about it ahead of time, and all of a sudden they have to seat someone. So to have the added burden of trying to maintain balance between town and ETJ would be difficult. Also, get people sick right before the meeting and during the meeting. So usually I have a handful just getting the full board seat in cases.
Part of that was also the thinking behind the town council passing the ordinance giving full voting privileges to all of your members. Because if the ETJ members were only qualified to vote on ETJ issues and not on inside the corporate limits matters in issue, it creates a nightmare in terms of making sure you've got the quorum of voting capable individuals that sit in for a particular case, say. So at least you don't have to worry about voting power in making the assignments.
I do have another question. Section 5, under meetings, Section A. So it says when there are less than 4 members present, we basically cannot have a quasi-judicial, we can't have a hearing. So I mean, if there's 4 members present, then it has to be a unanimous vote.
That's right.
At that point in time, can we delay the vote until we have a 5-member voting body versus making it a unanimous decision?
You always have the decision to continue, postpone, or defer cases. I think I may have mentioned that Raleigh, again, not to hold Raleigh out as a model, but Raleigh has it's an informal rule of practice. It's not written down anywhere. But if they only have 4 or 5 members present for a variance request, they will automatically continue the case because they don't think it's fair to require unanimous approval. And you all could feel that's good rule of practice or not. But I mean, at least in theory right now, I believe you all could conduct that item of business with just 4 members present because you have a quorum. But you do have that unanimous requirement there. That may not be a good thing.
So if you have 4 and then someone recuses themselves, we basically could not have a,
Can't act,
okay.
can't hear the case. Yes.
I will say that sometimes an offsetting consideration is the opinion of the applicant. And if they are feeling they're under an extreme time pressure of some sort, they may push for having a hearing. They also make their own estimate on the chances of them having opposition, no votes and all that. But usually if the applicant has a strong opinion on that matter, that's usually taken into account.
The res, I take it that was all the revisions that
Yes,
you
sir.
made since our
Yes, sir.
last meeting? Any other?
I think you all have clarified those very minor changes concerning the month of the selection of the chair, referencing the code provision and also town hall for municipal buildings. That's not something I don't think needs to be redrafted and come to you 30 days from now.
I think, well, we can, any other questions? I think we may be ready to consider adopting these. The board would like to move forward with a vote.
I'll make a motion to adopt them.
Got a motion to adopt by Mr. Casey. Do I hear a
That
second?
motion state that it's
With the revision?
With the revisions, yes.
Revisions, including the additional revisions from
Yes, with the additional revisions
That's
discussed
what he
today.
said. Yep. Okay, we have a motion on the floor to approve the procedures with the revisions as noted. I'll second. We have a second from Mr. Sims. All in favor, say aye. Aye. Opposed? Motion carries. Moves us down to new business. Any new business, staff? Yes, we do have new business.
I was just going to note that the town of Clayton has extended a permanent plan director job offer that has been accepted, and starting work on Monday, August 30th, is Mr. Benjamin Howell. He's served for the last 9 years working in the plan department for the town of Morrisville, and ironically follows some other folks serving in the administration here. He's also served as recently as president of the North Carolina chapter of the American Planning Association, so he's pretty well-known figure around the state, and as well as having exposure to the way planning goes on in different jurisdictions. So you will see him up here next month instead of myself, and I've certainly enjoyed seeing you all be appointed and getting your legs under you, and I think the town's in great shape with your service tonight. Thanks.
Thank you, Dick, and we'd just like to say thank you for all you've done. It's been a great resource in helping us get up and running, and we appreciate it. Wish you all the best in your future endeavors as well. So thank you very much. Appreciate it.
Thank you.
Any other new business? All right, hearing none, we'll entertain a motion to adjourn. Motion by Mr. Satterfield, do we have a second?
Second.
Second by Mr. Perricone, all in favor, say aye. Aye. Opposed, motion carries.
Let the record show Bob and I agreed on one thing.
Yes.